Welcome to Justice Counts, the podcast that goes beyond the law to what's important to you. Equal justice for all is a guidepost for our nation, but how do we achieve that? Here are your hosts, writer-commentator Bob Gatty and novelist-attorney Mark M. Bello.
Hey, thanks for joining us today on the Justice Counts podcast. I'm Bob Gatty. Today, author, lawyer, and podcaster Mark Bello and I are with Shari Belitz, a national trial consultant, keynote speaker, best-selling author, and former insurance industry professional. Shari is the founder of Shari Belitz Communications, a company that guides attorneys and insurers and major organizations across industries in leveraging social psychology to succeed at settlement or trial. Today, we'll talk with Shari about leveraging social psychology to achieve favorable litigation outcomes. Here's Mark Bello to welcome Shari to Justice Counts.
Hello, Shari. Welcome to Justice Counts.
Thank you so much, Mark. It's great to be here today.
As we discussed off air, I met you, I found you on LinkedIn. I understand that you have a story about how you used LinkedIn during the COVID crisis to start a trial consulting business, correct?
I absolutely did. I leveraged LinkedIn and built my entire business using LinkedIn and still get a lot of business from LinkedIn. So shall I launch into that short version of that story, Mark?
Yes, please, because I have a lot of questions for you that relate to what we do.
Okay, excellent. So anyway, here we go. It was March 2020. I was working for a trial consulting company. Everything was wonderful. I had 10 speaking engagements lined up. I was bringing in business. Things were fabulous. COVID hits. I live in New York City. I was at the epicenter of this. The powers that be kind of hit the panic button. Things were not happening in person. The legal field really just did not know how to pivot yet to a virtual world, though did rather quickly. So I lost my job. I cried for a day. Then the next day I figured out how to file unemployment, something I never thought that I would have to do. And then the day after that, I said, okay, let's get to work. I am going to start a business, and I'm going to start a business teaching lawyers how to leverage psychology to achieve favorable litigation outcomes. And whether that is settlement, whether that is, favorable litigation outcomes aren't a zero-sum game. So it can mean different things to different parties and different lawyers. So I said, this is what I'm going to do. This is my passion. I love speaking about it. I love teaching about it. And I'm going to start this company. And I didn't know the first thing about how to put out content on LinkedIn or how to build a website. I called my friend who worked at a gym. I figured he was pretty much unemployed as well. And I said, and everyone that works at my gym is a millennial. So I said, Brian, you know how to build a website, right? This is something you guys know how to do. You're born knowing how to do. He's like, yeah, no problem. I'm like, okay, I'm hiring you to build my website. Let's do this. So he built me this website. I had a fabulous website. And I said, okay, now I need to fill it. And I just put my head down. I started writing articles. I started really researching what my industry was interested in, which was virtual trials. That was going to be something that was going to be happening given the pandemic. That was various issues with jury pools like selection bias and various other statistical appealable problems. And I just started writing like crazy. And I would post on LinkedIn. I'd post articles. I'd post short posts. And I started gathering a following from these posts. And some of them were Not so much business, but they were a little bit more personality. I talked about what it was like living in New York, living at the epicenter, homeschooling two young kids, losing my job. And I just really, from being myself and from pushing out a lot of value there, I started getting a following. The more I wrote, the more speaking engagements, podcasts, webinars people were asking me to do. I was doing all of this for free, but I had a lot of information to put on my website. And then eventually I hooked up with a networking group and things really just started taking off from there. And I got my first trial consulting contract summer of 2020, did a little bit of a pivot with the business, turning it from a communications business to a traditional trial consulting business. And off I went.
Now, you were a lawyer before, right?
Correct. And I
How long
still
did how long did you practice law?
I like to say I practiced for a hot New York minute because I was at a firm for a hot New York minute, but then I was in-house for 15 plus years. So, and I keep my license up. So I am still paying that money like 25 years later. So yes, I'm technically a practicing lawyer.
An education besides the law related to psychology that creates the ability to be a jury consultant. Can you talk about that for a second?
Sure. So during my time in-house at an insurance company, I decided to take a leap of faith.
The dark side, the dark side, as I call it.
The dark side, as you call it, the bright side, as I call it. So I say I went to the bright side. Your dark side is my bright side, but I went to the bright side. Really wonderful company, and met a lot of fabulous people who are now friends and clients, and just all sorts of great people. And at a big corporation, when you're pretty young and pretty new, there's a lot of opportunities to learn how to do things. There's a lot of training. There's a lot of public speaking seminars. There's really a lot that you can learn from being at a large corporation. So I took advantage of that and learned a lot about the insurance business, the business of my insureds, and just enjoyed my time there immensely because I did like the people that I was working with for all those years. But I took a leap of faith when I was there, and I pursued a dream, which was to go back to grad school at night to study forensic psychology with a concentration in jury research and jury science. And I did that at John Jay, which has a wonderful forensic psychology, legal psychology program. And I got to study not just juries, but for a semester, I studied psychopaths, which was an interesting juxtaposition to working in corporate America during the day and studying functional psychopaths at night. And that was wonderful. I learned how to give the Rorschach inkblot exam, which I would give to every one of my coworkers. And they would line up at lunch, and I'd give them the Rorschach exam in my office, and analyze it for them as practice. I had classmates who were hostage negotiators. I had a classmate who was an FBI profiler. It was just a really fascinating time in my life, but I was laser point focused on the trial consulting. But it was really fabulous going back to school and studying something I was passionate about, as opposed to going to law school right after college and not really having that real life experience. It's just sort of a different experience.
Now, your service, correct me if I'm wrong, but it's all about using behavioral science or psychology, for lack of a better way to say it, to analyze human behavior and select what I'm going to call the so-called right jury, correct? Can you give us a brief sketch as to how you go about doing that?
Sure. So we have various services, and it's funny because when you hear that someone's a jury consultant or a trial consultant, naturally everyone asks me about voir dire. How do you select the perfect jury? How do you select the perfect jury? And I tell them, well, first of all, voir dire is just one of many services. We do mock trials, we do focus groups, we do theme development reports, we do juror perception studies. Voir dire is one of the other services we do, and we actually call it deselection of the jury, because rather than trying to get that quote unquote perfect jury, we are trying to get those biased jurors off the jury. We are trying to there's recognition that there is no perfect jury, but there are people who can actually tank your jury. And in my case, in defense case, it's those nuclear runaway verdicts. So that is what we are trying to avoid.
Do you truly want a neutral jury, or do you want a favorable jury?
That's an interesting question. I mean, obviously, we are, as trial consultants, we are not advocates, but we really, when we're working with a trial team who is an advocate, we want a favorable jury, but we also realize that we would rather deselect those that are unfavorable and have a neutral jury that is maybe a more realistic expectation. But yes, favorable, of course, favorable. Anyone too favorable is going to get struck from the jury by the other side. So we will settle with neutral and getting those biased jurors out, send them home sweet home.
This sounds like the Bull TV show that happens to be one of my favorite.
It's so funny. I wanted to love that show so much, and I was so excited to watch it. And then I did, and I'm just like, wait, no, this isn't my life. This is too glamorous. This is too flashy. I'm like in my sweatpants, like glasses, like writing case themes, like nerding out on statistics. Like I'm not this cool. So
you don't have the
bull is bull.
Do you have that big bank of TV screens where
no.
somebody can sit and I can't figure out how they can read the jury's mind just by looking at those TV screens, but that's just me.
No.
He's also so arrogant. I mean, he's the smartest guy in the room. He thinks he's the smartest guy in the room, and it drives me crazy. That's my problem with Bull. But I worked in the civil system too, as you know. On the opposite side, you're on the insurance side. I was on the plaintiff side. In the civil system, jurors are often biased based on skin color, on employment status, on lifestyle choices, on gang affiliation, even when they look at witnesses. How do you combat that or deal with that in your process?
Well, that's an interesting question, especially in light of COVID, because remember, my business is a COVID business that does not know a non-COVID times. And in COVID times, we have I call it COVID's gift. We have the gift of a robust supplemental questionnaire. Judges do not want they do not want full courtrooms for many, many hours or many, many weeks or anything like that. So they're allowing lawyers to have a more robust supplemental questionnaire, ask more questions, and really shorten up oral voir dire. So we are allowed to ask many more questions in our questionnaires. And the benefit of that, as opposed to asking orally to a jury, is you're going to mitigate something called the social desirability bias. And the social desirability bias is just something that posits that we like to present ourselves in the best light possible, present the best picture of ourselves, not just at jury duty, but in life. Like we always say, we vote more, we exercise more, we're doing more work, or whatever it is. But when people are on a jury with people they don't know, with authority figures, they are likely to answer questions in a way that frames them in the best possible light. Whereas if you have a robust questionnaire where they're just answering questions, they're just writing it, they don't have to really face anyone or face any kind of judgments. They are more honest in those questionnaires than they would be if an attorney or a judge is questioning them. So I say that that is COVID's gift. That was probably a long-winded way of answering your question, or maybe not completely answering your question, but I wanted to put that out there because that's very important to at what we're doing now, and that may be something that sticks around long after the pandemic.
What about insurance bias? Do you find people are biased against large corporations, or on the contrary, they're paying premiums? They think a plaintiff verdict will cause their insurance premiums to go up. Do you find those kinds of biases exist?
I do. And where we find them is through research and actually through mock trials, which is so interesting. So whenever we do a mock trial, there is always one or two jurors that bring up insurance. One or two jurors will say, well, won't insurance cover this anyway? So there is an awareness about insurance. As far as a bias against big corporations, there's absolutely a bias. And I've done a lot of research and writing about this bias. And in fact, in grad school, I did my paper on this bias. There is a bias. There's an uphill battle against corporations, and it's being exacerbated by our younger juries, our millennial and now Generation Z juries. However, it's not because, and popular belief is, oh, deep pockets, they have deep pockets, but that's not it at all. The research shows that that corporate bias is because corporations are held to an enhanced, sometimes superhuman standard just because they are corporations. And there have been studies that have shown if you take an unmarked truck driven by Joe Schmo is in the same exact accident as a marked truck by a Walgreens or by big corporation name on it, that liability is more likely to be assessed against that corporate vehicle and that damages are likely to be higher. So there's an absolute corporate bias. It's getting worse. I talk and write about that a lot when I talk about nuclear verdicts.
You obviously are specialized in civil cases, but I want to talk about criminal cases for a second. Your Justice Hugo Black, as I'm sure you found out in your studies, has a famous quote about this. There can be no equal justice where the kind of trial a man gets depends upon how much money he has. And if you think about criminal defendants like OJ and Martha Stewart and Michael Jackson and Robert Blake, all of them had the financial resources and power to hire a jury consultant to help them in their trials. Are you concerned about what Justice Black was concerned about, that your service can only be used by the rich and powerful?
We'll get Shari's response to that question right after this break.
It is a concern. I would be lying if I said it wasn't a concern. Early on in my career, I worked at Legal Aid, which is New York's public defender. So I saw what it was like. And there were some very dedicated, very smart lawyers there who really had visions of justice and really had just their hearts were absolutely in it, but they also had ridiculous volume case file. They had so many things against them. They certainly didn't have trial consultants. And yes, I believe that is the case. There is an absolute, as with most things in life, I do think money. I don't want to say that money buys justice or money buys verdicts, but look, we know the truth of the matter. Money buys good experts. Money buys a lot of things. So yes, absolutely, that's something I'm not going to say that things are equal, because they're not, and my time at Legal Aid certainly indicated as much.
How might your service be used to manipulate justice or prevent a fair outcome? Is that a possibility?
Oh, there's a question.
Okay. You know what? I don't know about manipulating or really preventing a fair outcome. Again, I work in the civil arena. I'd absolutely do pro bono cases, criminal defense. I haven't had any yet, but it's something I would absolutely do. And my partner's done quite a few. So as far as how would it manipulate justice, I don't think it would manipulate justice. The plaintiff's bar is, for a myriad of reasons, very much ahead of the defense bar, especially in the last 10 years. They have a great grasp on social psychology. They are excellent storytellers. They have litigation funding, which is funding, and we talked about this off camera, which is funding good experts, which is giving them the ability to really take risks that they wouldn't have to take. And they have a lot of courtroom experience. Defense lawyers have the deck stacked against them. As we talked about, we have a bias, we have an uphill battle against a corporate defendant. When you're talking about insurance defense, you're also talking about a really tricky political tripartite relationship, something like many of us haven't even heard about since ethics in law school. But that is difficult. That is really akin to having two bosses. Yes, we know the insured is the client, but when it's the insurance company with the checkbook, when it's the insurance company doling out the cases, it's really, it's kind of an inherent conflict. So you have a very tricky political tightrope that you're walking. So as far as getting a jury consultant in there, and most plaintiffs for large catastrophic cases do have a jury consultant in there, I don't think it is manipulating justice. I think it is really helping to evaluate cases, which are then often settled. After a mock trial is probably the best time to go to the settlement table, because you have an evaluation of your liability and damages. And then if you do get to trial, helping lawyers develop a theme, helping lawyers get rid of their biased jurors. I don't see that as a manipulation. I see that as good advocacy, and also really leveling the playing field, because plaintiffs' lawyers are running away with verdicts.
You made a good point that I want to discuss. The thought is that your service is typically used during jury selection. And for those of our listeners who don't understand what jury selection is, there's a process in picking jurors and using a consultant like Shari to help you pick jurors that are going to be favorable to your point of view, at least in theory. But what you just talked about is using your service way before a jury trial is even contemplated. The mock trial and potential jurors that may in fact be selected a year or two from now are discussed and considered in a mock trial setting for the purpose of deciding whether to settle a case or not. Can you talk about that? That's an interesting concept.
Sure. There are so many interesting things about mock trials. I actually have one this Thursday, and there has never been a mock trial that I've walked out of that I have not learned something really valuable to bring forward with me. So let's talk a little bit about settlement. People think it's funny that I'm a trial consultant, yet I'm so in favor of settlement and alternative dispute resolution, such as mediation, especially during the pandemic where dockets are so clogged. When you do a mock trial, now each side, plaintiff side and defense side, or it could be like a commercial litigation, two companies, whatever it is, you're going to have litigants and their lawyers are going to have something called confirmation bias, where they are so immersed, so in love with their case, they are so enamored by their case that they're not seeing the strengths of the other side and they're not seeing their weaknesses. So they're not really giving it a full evaluation. And the only way to do that is to put it forward in front of a representative demographic where they're going to be trying the case. So if they're going to be trying the case in Cook County, Illinois, you need to get a sample of Cook County, Illinois jurors and try the case in front of them. I mean, basically a very abbreviated trial of the case. So what we do is we do that with mocks, and you end up, I always tell my clients, I say, you're going to end up with one of two things, maybe both. You're going to either end up with leverage where you see, wow, my case is that good. I really should be taking this to trial because it is that good. Or I should be taking that report to the mediation table and saying, look, this is valued. This isn't valued at $20 million. This Cook County jury's valuing this at $300,000. So you're going to either walk out of there with leverage, which rarely happens, or you walk out of there with knowledge. Oh, wow, I didn't think this was worth $10 million, but this jury seems to hate my client for X, Y, and Z. And they think it's worth $15 million. So you're going to walk out with that knowledge, and that's going to really help you settle your case or make a very informed decision based on quantitative and qualitative data that's extracted. You may also find themes that you never knew existed, or just get like really great nuggets of information. Some of it you may want to, if it does go to trial, work into your opening or your summation or a cross-examination, for example. So you really get a very valuable, evaluation of your case. But what I've been noticing lately is you also get information that is so important. For example, we were mocking a trucking case recently, and it was I'm from New York City. I don't know from different terrains. Everything looks the same to me. I just know Central Park and, streets and highways, and that's it. But we were mocking a case in an area that had various terrains. They pulled jurors from, some lived in the mountains, some lived in more flat ground, some lived by a body of water. And based on where they lived and based on their experiences with truckers, they all had very different views. So it gave us some very valuable information, like you may not want people who live in the mountains because this is their view. You may want people who live more in an urban, flat, terrain environment. So, I mean, these are just invaluable exercises for evaluation, and then also for nuggets like that.
Or the you may want solution is one way of looking at it. The other way of looking at it is, this is what you're going to get, therefore you're going to lose, therefore you ought to settle. So in some ways, your service might educate your client as to what biases they can assume they will encounter that will help them make a rational decision on how to resolve their case, right?
Absolutely. This happens all the time because, again, they have confirmation bias.
Right.
They are in love with their case. They don't think the plaintiff's case is that strong because of X, Y, and Z. And then you put it before a mock jury and they start seeing all the weaknesses of their case. They start seeing the strength of the other side, and they're pretty surprised. They are pretty surprised. I think juries are also surprised, and I've seen this a lot. If liability is just not there on the defense side, and I've seen a lot of cases where liability is really just not there, sometimes there is such a sympathy to actually, well, we have to give her something. Can we give him something? Look at these injuries. We need to give them something. So you could end up getting at least a small assessment of liability just so they can award some money to the plaintiff if there is that sympathy. So that's very surprising for defense attorneys if they think liability is a slam dunk.
It's funny because I was going to ask you, shouldn't the system strive to focus on achieving justice rather than just defeating your opponent? But that mock trial process, as you're describing, does exactly that. It focuses more on, this is why you're going to lose, or this is why you're going to win. You have the better case, or you have the better potential outcome. Therefore, you should do this. So I like that use of your service vis-a-vis the use of your service to pick what I'm going to call a stacked jury, and we can talk about what a stacked jury is. I don't particularly care for that term or that process, just like I don't care for a stacked Supreme Court. but I like the use of your service for mock juries for that reason. It tends to support the concept of justice rather than subvert it. Yes?
I agree. And I also think it is a real saving of resources for all sides. Mediators have told me that when parties come for mediation following a mock trial, it's more productive. They're able to get more cases settled because there's a realistic evaluation of the case. So you could settle a case and save in indemnity and save in defense costs, save in time. And realistically, with a pandemic that is just seems to keep picking up speed, and we don't really know when this is going to end and when we're going to be back in court. I mean, we have these clogged dockets. We're slowly back in court, but really prioritizing criminal cases at this point. Alternative dispute resolution is the way to go. And by mocking the cases, you have a much better chance of reaching resolution.
Talk to me about jury pools themselves. In the old days, like Harper Lee depicted in To Kill a Mockingbird, you couldn't get a black person on a jury.
Mm-hmm.
Today, there are fewer examples of unrepresentative jury pools, but I presume it's still a problem. Is there still room for improvement?
There is so much room for improvement, and I'm glad you brought that up because this is one of my first concerns when the pandemic hit, and it was kind of the first articles I started writing about virtual jury trials because that was going to be a reality, and it is a reality. There are a lot of virtual jury trials, or there are hybrid trials where part of it is virtual, and my concern there was going to be a selection bias. You were not going to get representative juries, especially in the early days of the pandemic where COVID has had a disproportionate effect on minority communities, on urban communities, and you were not going to get a representative jury. You were also not going to get a lot of women on your juries because whether they were in person or whether they were virtual, because stereotypically women shoulder the burden of child care. And, there was a lot of homeschooling going on at that point, and a lot of people would have to defer. People would have to defer because of age, both virtual and in person. In person, because it was a health risk to older people who may have had pre-existing conditions, and this is prior to vaccination, but also they may have not had the knowledge about the technology to really do a proper virtual trial. You really need a laptop. You can't use an iPad or use a phone. So you have a lot of selection bias there. And this is an ongoing problem with either in-person pandemic trials or virtual trials. Now we're having vaccination issues, and there have been judges that have, this was in a big trial in Ohio. I'm trying to remember. It may have been one of the opioid trials, where the judge was asking that everyone be vaccinated for the trial. And one of the lawyers made a motion saying, you know what, you're going to skew the jury pool if you're only asking, I mean, for the purpose of safety. And this was before the Delta variant, actually. So it was going to be much safer if you had all vaccinated people, but you were going to also really skew that jury pool.
It's an interesting balance. It's an interesting balance.
Yeah, around political lines. And it's kind of funny because my partner and I, during the 2020, during like the heyday of the pandemic before vaccination, we were asked to do some in-person mock trials in states that were still very much open. We're in New York and Philadelphia, so we were very much closed, but we were asked to do some mock trials in person down south. And we had to say, first of all, it's going to be ridiculously expensive because we're going to have to do them in such a venue where we could social distance. We're going to have to use PPE, but you're going to also get a really skewed pool because you're going to get people of maybe one political party that are fine to show up in person without their masks. And you're going to really be excluding people who don't want to show up in person during that time. And you'll get a much more representative group if you do this online. So there's some really interesting selection bias issues with politics and this virus.
And also media coverage. Media coverage has a big impact on what you do, does it not? The jury consultant has to weed out biases that are kind of installed, if you will, by the media.
Absolutely.
You have people, for instance, in the criminal world who are tried and convicted in the press, as we call it.
That's absolutely true. And there's a whole body of psychological studies on pretrial publicity and how it affects verdicts and how it affects jurors. And what I like to say is, I did a little article, or it was a post or something. I said, what do you do when plaintiff's co-counsel is the media? Because every single day they could be pushing out something, whether it's a big high profile pharmaceutical case, whether it's a big high profile criminal case, whatever it is, there is information. And like you said, like case can be not only tried in the press, but jurors can be primed. And that's a psychological concept that I try to instill in my clients. Like, jurors are being primed. They are being primed. I mean, they can be primed years before they get into that courtroom.
I want to play a quick true and false with you, if you don't mind.
Mm-hmm. Sure.
We need more pro bono free jury consultant services. True or false?
True.
We need state-sponsored access to jury consultants for indigent and low-income defendants.
Excellent idea. True.
Even if we do that, we'll still have inequity because the best consultants will still be the ones you can hire. Correct?
I'm going to say it depends. You know what? To be determined, because actually,
to be determined?
So here's a person like me. I think I do a great job. I know I do a great job. I'm dedicated, but there are also trial consultants that have been around for many years. They've made many millions of dollars. And you know what? Maybe they're close to retirement and would love to do just a bunch of pro bono cases. So I don't think you would necessarily get, you might be more likely to get some really experienced people if you look at it like that.
Lousy judges or lawyers and a lousy jury selection process has a much larger impact on the outcome of a trial than a jury consultant could ever have. True or false?
True. True.
Jury consultants can actually help balance the scales of justice in situations like I just described, where the judging, the lawyering, and the jury selection process are substandard. True or false?
True. True.
If a lawyer can get out of his own way and avoid being too arrogant, a jury consultant can help that lawyer ask questions at voir dire that will help expose potential jurors' bias.
True. And that happens all the time with a lawyer's arrogance. It is sometimes a little bit of a dance that the consultant has to do if the lawyer's not working with them.
As the use of your service expands, both sides will utilize them, which will limit their effectiveness. True or false?
I think that's false.
Okay, explain, please.
Okay, so it sounds like the question is they will cancel each other out. But again, I don't think it's a zero-sum game. And I think there are many uses of trial consultants. And I think if you get really effective trial consultants on both sides, you're going to actually not wind up in the courtroom. You're going to wind up at the settlement table, saving a lot of money for both sides and really a lot of efficiency and time and resources. So
I agree.
That's one way to look at it.
I agree. I think that's the best use of your service is way before getting ready for a trial.
Absolutely.
The legal system should embrace the psychological expertise of jury consultants and find ways to use the service to ensure fair trials.
Absolutely true. And not only that, there are so many ways that the law is behind social science. And I really think they should embrace social science, especially with respect to the criminal arena. There's just so many examples.
Trial consultants are not a threat to justice in civil or criminal trials. They're part of the solution to assure justice.
True.
There is some criticism, correct, in your industry about creating this financially, for lack of a better way to say it, induced impartial jury, that the person with means can hire people like you, the person without means cannot, and that creates this imbalance of injustice. At least that's a theory anyway.
Well, that is a theory. And I think what's interesting about that, and again, that's kind of conventional wisdom. Oh, you're a trial consultant or you're a jury consultant, you pick juries. Well, actually, my work starts way before, and probably aside from mock trials and focus groups, I think my best use, the best that I can do for a client is actually help their key witnesses get prepared for deposition. Because once you get those witnesses prepared for deposition, that again, it creates a leverage, it creates a knowledge, and it creates a better opportunity to get to the settlement table and to get there early. So I really view a lot of what I do as a tool to get a case resolved early and expeditiously. I think a lot of times, and it's funny, I had a friend from law school call me. He was picking a jury, and he's a defense lawyer in a very plaintiffs-oriented county, and he said, hey, like, my carrier wants to know, like, if you can help pick a jury. And I said to him, where are you? Tell them to get out their checkbook. Like they're calling me too late. I should have been there prepping their witnesses or doing a mock. Like I can't conjure up a jury. I'm not a magician. I'm an evaluator.
Shari, I wasn't going to ask about this, but you raise a point that I think is important and needs to be discussed. When you describe prepping a witness, we're not talking about helping a witness distort the truth. We're talking about what?
So in most cases, most large cases, witnesses do need help. There is a lot of help that witnesses need. And most of it is because they have anxiety, whether it is an anxiety, let's say that they're like a corporate employee or something, and they have anxiety they're going to lose their job. They have anxiety that they're going to be sued. They have anxiety maybe that there would be criminal sanctions. There is a lot of anxiety, and having that anxiety prevents them from giving compelling testimony. So first of all, I have a 10-step prep that I do with witnesses, but that is often the largest problem, is to actually get over that anxiety so they can testify in a credible, compelling, persuasive way. Then there are often things that, again, unless they're expert witnesses, they're not really professionals, and maybe they have issues with demeanor. They're biting their nails, they're playing with their hair, they're not looking at the camera, or they're not looking at the questioning attorney, and all of these things that they're doing. And there may not even be a video camera there, but all of these things they're doing, the other side is assessing them. They're being evaluated. So if they are not doing a good job with even things like body language, their case value is being affected. But if they come in and they're a compelling, smart, articulate, honest, likable witness, that's going to be taken into account, because no one on the other side wants to see that person in the witness box. So that's being taken into account when you're accounting for settlement evaluation. So I work with witnesses, and that's truly the Shari Belitz communication aspect. We work on communicating. Sometimes there are very sophisticated witnesses like doctors or corporate executives, and they don't realize they're being arrogant, or they're using language that a jury isn't going to like, or that they aren't going to understand, and they need work on that. There are so many areas they need work, and it's unethical, and it's actually not even smart to script anything they're going to say. I never script anything a witness is going to say. It's better for them to have an understanding of the gestalt of the case, the whole picture of the case, because if they get tripped up, if they get tired, they need to know where to go back. So we work on that.
I ask all of my guests this question at the end of each podcast. What does the word justice mean to you?
Oh, that's such a good question. And I should have thought of that before. So I'm kind of off guard. Justice, what is it? Is it the right result morally? Is it the right result legally? It's kind of interesting to think about the intersection of morals and the legal system. And you do hope that the legal system does take into account morals. So I'm going to say it's probably not what is morally right. It maybe leans more towards what is legally right. But I'll have to really contemplate that. That's an excellent question, and it gives me some food for thought, even though I'm not able to completely give you an answer. It gives me something to think about.
You can send me an email.
I'll send you an email. Exactly.
Bob, I told you this would be an interesting topic. Did you enjoy it?
I did very much. I thought it was great. And I had no idea you guys did so much, Shari, and it's very impressive. And so thanks so much for being with us. It's been a fascinating discussion. Hey, you know what? If you haven't done so already, you guys, please check out Mark Bello's Ripped from the Headlines Legal Thrillers, all available at Amazon and other major online booksellers. He has quite the hero in attorney Zachary Blake, who fights for justice on all fronts. His books are Betrayal of Faith, Betrayal of Justice, Betrayal in Blue, Betrayal in Black, Betrayal High, and Supreme Betrayal. For more information, just check markbello.com.
Shari wrote a book. Shari wrote a book too, I think, right?
Yeah, tell us about it, Shari.
Sure. I contributed to an anthology last year. It's an Amazon bestseller. It's called #Networked, and it is about how 20 women lawyers came together during the pandemic and really lifted each other up personally, professionally, and we each told a chapter. It's kind of based on, I don't know if you're familiar with the Decameron, but I'm sort of a lit nerd, and it's the Decameron is also a compilation of stories that was written during the bubonic plague in the 1300s in Italy. So this was our COVID version of that, but it's very much modern themes.
Well, it sounds fascinating. Where can people find it?
People can find it on Amazon. That's #Networked.
Okay, thanks. I just want to let you guys know that Mark Bello also has a brand new book just out. It's called Betrayal at the Border, and it deals with the immigration crisis. So check that out. You can find it on Amazon.com or at markmbello.com. Now, this is Bob Gaddy signing off from Justice Counts. Oh, there's a question.